Hello, everyone. Welcome to the 19th episode of the TCLF One-on-One series. Through the One-on-One series, we aim to interact with the best legal professionals in India and abroad. And we're thrilled to have Ms. Kshama A. Loya as our guest for the 19th episode. Ms. Kshama is a leader in the international commercial and investment arbitration practice at Nishith Desai and Associates. She is a graduate of ILS Law College, Pune, and holds an LL.M in International Commercial Laws from King's College London, and has also studied negotiation and dispute resolution at Harvard Law School. She specializes in international commercial and investment treaty arbitration, litigation, and pre-litigation strategies, and holds leadership positions in organizations such as the Inter-Pacific Bar Association, ICDR, and Chartered Institute of Arbitrators. She also writes regularly on contemporary issues of international and domestic dispute resolution. It's an honor to have you here today, ma'am.
Thank you,
So
Tanvi.
you specialized in international commercial arbitration during your master's at King's College London. Could you tell us more about how you developed an interest in investment arbitration and how your practice and various positions have developed in both areas of law over the years?
Thank you, Tansi, and the Contemporary Law Forum for inviting me on this session. Um, Tansi, I studied at King's in 2010 and 11. Uh, so, in the first half of my LLM, King's opened application process for participation in the Skaddenup's FBI mode, the International Arbitration Mode competition. Now, I barely knew anything about international investment law then, but I remember recognizing the value of this opportunity and, above all, being really excited to learn a new subject of international law, not just through classroom lectures, but through application of mine on a case before arbitrators. So I studied for the interview and got selected on the team. The best part was that we had robust coaching from the finest coaches for nearly 8 months. Now, I've never seen this kind of seriousness and rigorous training for a moot competition. Um, that year, Kings made a record by winning the first prize in all except one award category. And then in the second half of my LLM, the international arbitration module involved lectures on investment arbitration by the late V.V. Wieder, fondly remembered as the father of investment arbitration. So I was taught by faculty and coaches who took knowledge and application of this specialized subject very seriously and instilled passion in me for the field by sheer example. Since then, I've continued work in this field, and my practice and positions of responsibility have only helped me engage in more interesting work in both investment and commercial arbitration.
I think that is quite interesting. In fact, I think any lawyer or law student would attest to the fact that mooting does open up so many new avenues of law and to be able to develop an interest in that. So, over the course of your journey, what would you say has been most enjoyable and interesting about working on commercial and investment arbitration matters at Nishith Desai, which does boast of a very robust international practice?
That's absolutely true. Our team at Nishad Desai believes in different work and being distinctly different as professionals. That's the firm motto. Hence, we focus on taking up complex commercial and investment arbitration matters that drive us to analyze critical complex issues of law. The culture or the way of work at Nishad Desai is to engage not just in a clear understanding of issues faced by clients, also focus immensely on anticipating legal, commercial, and practical issues that could be faced by clients out of the dispute. Now, this enables us to give an extremely holistic and often effective, innovative advice. I'd say this is what makes work truly interesting and enjoyable at Nishad Desai.
That does sound very interesting and for a place to work at, and very dynamic place to work at. But before Nishith Desai, you also worked as a counsel in the chambers of Justice Sanjay Gangapurwala. As a counsel before and a law firm attorney now, how would you approach litigation, commercial, and investment arbitration matters? And would you say it's difficult for young lawyers to be able to engage in all three streams and to switch between them?
So let me put it simply for the benefit of students and young lawyers. For lawyers, everything starts with research and understanding of law and ends in application of mind. The quality of your work, therefore, depends on the depth of your knowledge and the strength of your application of mind. This is what I learned as a counsel. And this holds true for anything you do in the profession of law, whether it is litigation, commercial, or investment arbitration. So, my approach to matters involves a close scrutiny of facts and issues, assessment of impact on the client, which is very important to understand, in depth research of the relevant law, and as I said, a critical application of mind. But above all, as my senior always said, conveying clear thought through good advocacy. As a professional, I think there are three questions I ask myself: what is the impact on client? How can I achieve the best outcome in the most efficient manner? And what is my value addition to the law and to my potential? That is how I approach litigation, commercial, and investment arbitration matters. And that makes it seamless for me to even switch among these three streams.
Yeah, I think that is extremely valuable advice. And coming to investment arbitration in particular, it is known as a very specialized area of law. As someone who has developed a very robust practice in this area, what would you say is important to keep in mind while developing a niche in investment arbitration within the larger ambit of a dispute resolution practice?
I'd say two things. Um, One, a clear understanding of international investment law, public international law, and private international law. These three are very important uh, to excel in this field. The second thing is recognizing that the an investment arbitration dispute or investor state dispute forms at a juncture of individual or commercial interests on one hand and state sovereignty and policy on the other. So, a professional dealing with such a dispute needs to understand this balance and shape the case accordingly, either for arbitration or for settlement.
Yes, that is very true. I think the added aspect of public international law and public law is what differentiates investment treaty arbitration. And while this is a very niche area of law, it has gained a lot of traction in India, especially in light of the highly anticipated awards in the Vodafone and Cairn arbitration cases. How do you think investment treaty arbitration in India has developed over the past few years? And what impact do you think these decisions will have on the growth of this field in the future?
I'd say the development in India can be put into two buckets. One is in the form of a reaction, the other is in the form of action. On the former, 2012, after India lost her first BIT case initiated by White Industries under the India Australia BIT, um, a spate of BIT cases ensued thereafter. Uh, Now, India reacted to these cases by terminating 69 out of its 84 BITs since 2016 and introducing a very state centric model BIT in 2016. So that's one development as I see it. Uh, on the action front, we observe that, uh, at least we note that India now takes its treaty obligations and treaty arbitration proceedings seriously. And there is greater discourse and dialogue on international investment arbitration in government corridors and our judiciary. So, this is at least a welcome development, Tansi.
Uh, yes, I think that is quite true. 2016 was definitely, I think, a phase where new developments in investment treaty arbitration were ushered. And now coming to the substance of the anticipated arbitration cases, which were the Cairn and Vodafone cases. Now, a key argument raised in the Cairn case was that tax is an integral function of India's sovereignty and therefore cannot form a part or is a subject of investment treaty arbitration. Why do you think India's jurisdiction argument in this respect was rejected by the tribunal in Cairn?
This is a question that really could involve an hour's discussion, 2 hours discussion, maybe more than that, and it's very interesting. But I will make it brief for the benefit of students and young lawyers uh, who have tried to understand the Ken dispute. Essentially, while objecting to the tribunal's jurisdiction under the BIT, India had argued that one, taxation measures are beyond the scope of the India UK BIT uh, by an implied exception. So, parties have not agreed to submit the disputes arising from tax measures to arbitration. Alternately, India argued that even if parties may have consented under the BIT to submit tax disputes to arbitration, this consent was invalid because the dispute is not arbitrable under mandatory rules of Indian law, the lex arbitrii, which is Dutch law, or international public policy. So these were broadly the two limbs on which India challenged the jurisdiction of the tribunal under the India UK BIT. Now, the tribunal first assessed the nature of the dispute. It said that the dispute is tax related investment dispute as opposed to a tax dispute. Now, what's the difference? It's huge. Tax disputes involve taxability of a transaction, which is whether a particular transaction is taxable under the applicable national law or laws of various countries if the transaction is an international transaction. Uh, it also assesses how a transaction is taxed. Now, taxability of a transaction is a matter of domestic law, but tax related investment disputes assess whether the state has violated treaty standards through the exercise of its sovereign taxation authority, resulting in liability or not. Now, this is not a domestic law issue. Whether the taxation measures taken by the state, irrespective of their validity or otherwise under domestic laws, violate international law, that is what the tribunal has jurisdiction to decide under an international investment treaty. So, with this viewpoint, the tribunal determined whether the way in which India taxed the Kane transaction uh, and through the 2012 amendment, uh, whether this violated treaty standards or standards of treatment under the India UK BIT. So that was the initial assessment of the tribunal on what is the nature of the dispute, because India kept arguing that this is a tax dispute beyond the scope of BIT, but the tribunal made a distinction and said this is a tax related investment dispute and hence covered under the BIT. Now, the initial two arguments by India that I was talking about, first was whether parties have consented under the BIT to submit tax disputes or taxation related investment disputes to an international arbitral tribunal. The tribunal held that, firstly, the clause that determines the jurisdiction of the tribunal needs to be interpreted according to the principles of the Vienna Convention on Law of Treaties. So the tribunal looked at the ordinary meaning, looked at the object and purpose of the treaty. It also went ahead and looked at contextual interpretation of the treaty, where under the treaty, I believe it is Article 4 of the India UK BIT, which has the national treatment and most favored nation treatment clause. Uh, this clause specifically excluded uh, preferential treatment or privilege given to parties under national law on taxation measures. So the tribunal held that where you assess the context of the treaty and you find a particular provision that exclusively or expressly excludes taxation measures, uh, the country or the host state cannot say that there was an implied exception under the treaty such that all tax related investment disputes should be excluded. If in a particular provision, India made it a point to negotiate and exclude tax related investment disputes, it was very well in the contemplation of India that tax related investment disputes could otherwise be covered under other provisions of the treaty except Article 4. So that was one assessment by the tribunal, where tribunal said that it appears that parties did agree to submit these disputes under the treaty to an international arbitral tribunal. The second uh, objection that was raised by India was that tax dispute, even if consent was given under the treaty, it is invalid because tax disputes are inherently non arbitrable under mandatory laws of India, under the law of the seat, and international law. Now, the tribunal, having initially already assessed that this is a tax related investment dispute, and I mentioned that that gives the tribunal jurisdiction under international law and under international treaties, the tribunal went ahead and said that a state cannot resort to its domestic laws in order to claim that a dispute is non arbitrable under an international investment treaty. So, domestic law is out. Then the tribunal has to consider arbitrability of a dispute under seat law, because ultimately the award is going to be tested as per seat law when it is challenged. Um, so the tribunal looked at Dutch law and found that tax disputes are certainly non arbitrable under Dutch law, but there is no such provision under Dutch law which uh, renders non arbitrable tax related investment disputes. Uh, and then you already have an assessment by the tribunal on international law, that investment treaty law and international law covers an assessment of tax related investment disputes and whether they violate standards of treatment guaranteed under the BIT. So, on these two grounds, which is consent and arbitrability, the tribunal rejected India's objections on jurisdiction. Fancy.
Thank you so much for explaining the distinction between tax and tax-related disputes so well. I think this is a very holistic understanding of the grounds on which the jurisdiction challenge was rejected. And now, keeping in mind the way forward, a key issue that both investors, Cairn and even Vodafone, will face if they successfully defend a challenge to these awards is to be able to enforce these awards in India. And this issue is something you've written about extensively. So could you provide a brief overview of the legal position with respect to non-recognition of investment treaty arbitrations under India's arbitration and conciliation law? And why does Indian law treat investment treaty arbitration differently from a commercial arbitration?
I must state that this is not a settled position, and it stems only from obiter dicta in two judgments delivered by single judges of the High Court of Delhi. Now, Section 44 of the Indian Arbitration and Conciliation Act states that Part 2 of the Arbitration and Conciliation Act will apply to an arbitration that is considered to be commercial under Indian law. While acceding to the New York Convention, India made a reservation that it will apply the convention only to differences arising out of legal relationships that are considered commercial under the national law. Now, the Delhi High Court, and not Indian law, has treated investment treaty arbitration differently from commercial disputes. The court has opined that the roots of investment arbitrations are in public international law, state obligations, and administrative law. Now, since the cause of action in an investment treaty dispute is premised on state guarantees and assurances, the court held that it is not, or the court opined that it is not commercial in nature. Now, this leaves treaty arbitration awards in a lurch, as they are neither governed by the Arbitration and Conciliation Act as per the Delhi High Court, nor by the Code of Civil Procedure, which at its closest governs foreign judgments of courts but not foreign awards. This is the trouble we are facing while treating investment treaty awards as per the Delhi High Court. Yeah, Tansi.
Uh, yes, that is quite true. In fact, I think since the Supreme Court hasn't ruled on this conclusively, there is an ambiguity in law. And just to conclude now, finally keeping in mind that certainty is quite important when looking at how strong an arbitration regime is, what do you think is the way forward for India to be able to strengthen its legal framework with respect to arbitration so as to encourage greater cross border investments and become an investment friendly jurisdiction?
The way forward for India in the absence of BITs and a remedy of treaty arbitration, I believe, is to have a robust national law and an expeditious judiciary that has a sound understanding of public and private international law. And having said that, Tansi, I have full faith in our judiciary. If you see in the Vodafone case, the Supreme Court of India had carefully analyzed the legal framework and recognized the practical manner in which companies engage in restructuring and accordingly had absolved Vodafone from liability. So while old investments may remain protected or continue to remain protected under sunset clauses of terminated BITs, new foreign investors could lie uncomfortably in our overburdened scales of judiciary in the event of disputes. And while the final outcome, akin to the Supreme Court decision in Vodafone back then, might heal investor wounds, the weight in courts sustains the value of investment. Uh, but it is a welcome move uh, by the finance minister. The finance ministry has proposed the enactment of a special legislation to protect foreign investors and resolve investor state disputes. So, what I read uh, uh, that the finance ministry has recommended mediation and establishment of special fast track courts for this purpose. But an investor state dispute settlement is a highly specialized area of law. So, uh, not just mediation and fast track courts are going to help, but it is critical for the judiciary or the mediator to have the requisite expertise and understanding of international investment law, public and private international law, national laws, all of this together, and to wield additionally a sound commercial acumen. Considering that these disputes may not be abundant in nature, I think it is my opinion that it might be more effective to engage lawyers with requisite knowledge, experience, and expertise on a rotation basis or for a fixed time period to take the judicial mantle. I think this could be a way forward now that India has terminated so many BITs and we could continue to face investor state disputes, not just under the old treaties through their sunset clauses, but also from new foreign investment, which India is attracting now. That's it from me, Tansi.
Thank you so much. That was very insightful. I think having an integrated system and a more robust and dynamic legal system that recognizes business and investment aspects as well would be a good way forward. And thank you so much for providing such interesting insights into the investment treaty arbitration framework in India and how it compares internationally. This was a pleasure. Thank you so much for taking out the time to speak with us today, ma'am.
Thank you so much, Tansi. I'm glad I could contribute and hope to remain in touch. Thank you so much.
Thank you so much, ma'am.